job my woman left. She took her out of my...
Sego, I'm John Kane, and I welcome you to Let's Talk Native on this Tuesday, May 21st. While this program may not provide a path to spiritual enlightenment, we do encourage, and in some cases start conversations. We don't do prayers or buffalo speeches. We do take a tough look at history, oppression, and survival. We talk about culture, the arts, politics, and identity, and we may step on a few toes along the way. But our real goal here is to bring people together by breaking down what separates us. We'll take on the false narratives and provide critical thinking to all that is heaped upon us. And we do it all live right here from the Cattaraugus territory of the Seneca Nation. So let's talk Native. But first, let me remind people that our audio streams at www.letstalknative.com. We stream the live video of the show on Facebook Live. We take that video and we put it on our YouTube channel, which is Let's Talk Native TV. And we take our audio and we put it up as a podcast after the show. So you can listen to us live, watch us live, or watch us after the fact on a couple of other platforms if you choose. I am the host of Let's Talk Native, and I am assisted by Jake Proud here in studio, who's managing our video and our sound. Hey, look, if you were wondering, we did go live for a little bit. We're testing out a couple of other systems here, and we might have overloaded one of our computers, so we went back to to our normal system. But we're going to play around with some things. We're trying to enhance our video streaming capabilities with incorporating a few more things associated with graphics and that kind of stuff. So if you see some changes over the next few weeks, that's what we're striving for. And of course, you'll also note that we do we produce videos for our YouTube channel that are informative. There's we do post these shows up as videos on our YouTube channel, but we also produce short videos between 5 and 15 minutes long that we can address a couple of issues, and we're going to post a new one up this week. But we're playing around with some different looks to what we're doing in terms of camera angles, multi-camera shots, and that kind of stuff. So bear with us as we try to enhance our our product here, and feel free to weigh in and offer your comments on what you're seeing, what you're experiencing, what you're learning, what you're not learning. We'd like to hear from you, and try to provide we'd like to provide some feedback to you as well. All right, so let me get into it. If you're watching, the U.S. court systems and legislation, that kind of stuff, everything seems to be about abortion on television, and with all the anticipation that with Alabama and I don't know what the other state was, one of the other states anyway, trying to pass these really oppressive, almost, for all intents and purposes, making abortion illegal and putting Roe v. Wade to the test. And the anticipation, the expectation is that their legislation in these oppressive states will get them back in front of the Supreme Court. And, look, whether it does or whether it doesn't, all I can say is these are issues that get politicized specifically for politics. And, it's hard for me to believe that conservatives really care about women having abortions. I think this is something that appeals to their base, and I think it really is kind of sad. But I'm not afraid to talk about the Supreme Court, and I'd like to talk a little bit about the Supreme Court, because while all that other stuff was going on, and not that it hasn't been covered, but it missed in a lot of this hubbub over, abortion legislation and what the court may or may not do. There was a couple of rulings over the last couple of months where one of Trump's nominees, Neil Gorsuch, has ruled with the liberal side of the bench on a couple of Native cases. And I'm going to mention talk about the two Native cases. And but even as I do it, I want people to be wary and not think that, oh, great, Native people have a champion on the Supreme Court. No, you don't. So, look, Neil Gorsuch has ruled competently on a couple of cases. But the devil's in the details on a lot of this stuff. And a lot of times when we win in court, there's language in the ruling that oftentimes isn't a complete victory. Got to go back to something like the Cabazon case. I take the position that neither California, the Cabazon California case, that didn't give us the right to do gaming, even though the Cabazons won in their gaming fight against California, nor did the Indian Gaming Regulatory Act give us the right to do gaming. We had the right. The Cabazon case, the ruling they got proved that we had the right. It didn't give us the right. The Supreme Court recognized that we had the right. But even as they recognized it, they put some limitations on it. They suggested that if a state does gaming, then a tribe can do gaming. Well, why should it matter whether the state does gaming or not? Why are we bound by what the state has chosen to do or not to do? I mean, so even when we win, there's always a trimming back of our sovereignty, of our freedom, of our right to make our own decisions on what we do and how we do it. And of course, IGRA would put significant limitations in terms of putting the state in bed with us on our gaming. So neither the Supreme Court ruling or the legislation that would follow it really gave us anything. They all seem to take something away. Now, but let me get to the two cases. Now, back in March, it was on March 19th, I think, the Yakima had a case before the Supreme Court, and it was Washington State Department of Licensing versus Cougar Den Inc. And Cougar Den was it was a Yakima company, and the case involved the state of Washington trying to impose millions of dollars worth of taxes against this company that was delivering fuel to Yakima gas stations, and they were trying to cite state law that required licensing. That's why it's the Licensing Department of Washington State. That not only required licensing, but required the remittance of tax for every gallon of fuel that is hauled on Washington State highways. Now, the Yakima have specific language in some of the treaties, and I got to be wary here. They have specific language about not being taxed for when they're conducting commerce, and the Yakima have been pretty assertive in asserting that right, and they fought this case. In fact, they even did something interesting that nobody else has done, and I applaud them for this. They went all the way back to the doctrine of Christian discovery in making their case against the state of Washington. I was glad to see somebody have the nerve to do that, because while the Supreme Court doesn't mind bringing up some of these old laws, and in a case of Ruth Bader Ginsburg, which I'll talk about later, citing specifically the doctrine of Christian discovery, the doctrine of discovery in a ruling, or at least in footnotes of a ruling. So I mean, they don't have any problem doing it. The courts don't have any problem, but when we defend ourselves, we don't go after some of this old stuff. And part of the reason is we've been advised by lawyers, oh, you don't even want to go there. Don't challenge Johnson v. McIntosh. Don't challenge the doctrine of Christian discovery. And they'll also say things like, oh, don't bother citing anything from the UN Declaration of the Rights of Indigenous Peoples. Because it's crazy. And to me, it's crazy that a Supreme Court can cite 15th century church dogma as part of their justification for rulings. But we're being advised every day by lawyers to say, oh, it's a waste of time to even mention the international law or standard established by the international law that's only a little over a decade old. I mean, I find that absurd. But anyway, so the Yakima and Cougar Den made a strong argument, and Neil Gorsuch ruled with the liberals on this thing in a 5-4 decision. And again, these are rulings that barely, I mean, these would be deadlocked. In fact, there's another case in Colorado, I think, that Gorsuch, because he's from Colorado and has had some dealings with some of the subject matter, another native case, it probably will go to the deadlock, because he will not be able to be the swing vote if he follows the same consistent pattern of recognizing certain treaty language as states try to impose their will on native peoples. But so back in March, again, Neil Gorsuch does something that I think surprised a lot of people. Didn't make a whole lot of news. I mean, didn't make a whole lot of headlines, because frankly, we don't make headlines, especially when we win something. But what happened in this case was a fuel distributor was successful in defending themselves against the state of Washington, who was trying to impose state law, state taxations, state regulatory controls over over a native business. Native business doing business with native businesses, and so Neil Gorsuch ruled with on the side of Cougar Den and the Yakima. So look, I'm not unhappy about that ruling. In fact, I'm pleased with the ruling. But I caution that we have to still keep in mind that they still don't recognize our right to be free and independent nations. And now the reason that they had to rule, or at least the liberals did, and Gorsuch ruled with the Yakima, is because there was some very specific language in treaties that they could not be convinced were legally abrogated. Yeah, they can be abrogated, but there was no facts in law that suggested that the treaties that the Yakima had, or the treaty the Yakima had, was no longer valid. So if it's never been specifically abrogated, if there's never been, I mean, I argue if we've never consented to giving up a right, then the right still exists. What the courts have usually said, well, we won't go that far. We'll say that if you had a right that was specified that you didn't give up, then we'll say, so it's still a bit of a slippery slope, and we still don't. It still isn't something that we should get too rejoicing about. Put it that way. But lo and behold, a couple of months later, and this was just a couple of days. It was actually just yesterday, May 20th. In a case involving this is the name is Clavin Herrera, who was Crow. He was hunting, and this goes back to 2014 when the incident actually happened. He was hunting, and he followed a herd that he was tracking onto I think Bighorn, state park or national park or whatever, but off the reservation line onto state land, I guess, and took some game, and then he was charged with again, he was charged by the state of Wyoming, and the case involved really language from a treaty in 1868 where the Crow gave up huge amounts of land to the United States, and it was very specific that although they were giving up this huge parcel of land, they did not give up the right, and they reserved the right to hunt on unoccupied land throughout the United States, not just in what would become Wyoming. Now, Wyoming would become a state, I think, in 1913 or something. Turn of the 20th century, turn of the century, anyway. And the argument that Wyoming was saying is once Wyoming became a state, that it somehow negated the treaty, and in that specific language in the treaty that said the Crow had the right to hunt on unoccupied land. Now, keep in mind, Clavin Herrera didn't shoot a moose off of somebody's backyard here. He went on to unoccupied lands and took some game, and again, I mean, it's crazy that these rulings are even 5-4, but in a 5-4 decision, Neil Gorsuch went with the liberal side of the bench. Now, again, look, these are good rulings to get, okay? And so I don't want to poo-poo the whole, the fact that one of Trump's nominees, no less, has sided with the. It's even crazy that it's right versus left, but sided with the left on these native cases. I'm just glad that somebody on the right, is willing to look at the real issues with the case instead of just this paternalistic view that the United States owns us. But I have to caution people, that's still the view they have. I mean, when Congressman Paul Gosar says, "Well, you guys are wards of the state," they really believe that. They really believe that we are incompetent, and the only rights we have are the ones that the United States gives us. Now keep in mind, both in the Crow case and in the Yakima case, they weren't giving us anything. All we were doing in these two cases, we were reserving, we were preserving, we were maintaining rights that we had always had: the right to hunt, the right to conduct commerce across our lands. And just because there was now going to be this shared land usage because of ceding lands for most purposes, didn't mean that we forfeited our right to travel across our ancestral lands to do, to conduct commerce. And it certainly didn't mean that we couldn't hunt anymore. But so when people talk about treaty rights, I think it's really important people understand that these are not rights given to us in treaties. These are rights acknowledged. So they are treaty acknowledged rights, put it that way. Treaty protected rights, not treaty awarded rights or granted rights. And I think it's important to note that. Because, look, it might be somewhat comforting and encouraging to know that one of the Trump-appointed justices has an open mind enough to rule for natives in these cases. But I've got to remind people, we still have some terrible rulings. I mean, some of these things, are not 5-4 decisions that rule against us, and that includes the entire liberal side of the bench. I mean, I'll go back to the mascot issue. The mascot issue, it was a unanimous court that because they ruled in a case involving an Asian U.S. or an American Asian rock band who wanted to call themselves Slants, which is considered a slur against Asian people. They wanted to copyright that name. The court ruled unanimously that somebody could copyright an insult, a slur, a derogatory comment. They could copyright that and make money off of it. And of course, it may not sound like a terrible thing when you're talking about an Asian group that wants to call themselves the Slants. Well, the problem is that this completely wiped out the case involving the copyright protection that the Washington football team has in their racial slur, for Native people as their name. So by ruling unanimously in favor of this Asian group being able to call themselves a slur, they essentially ruled unanimously for the Washington football team to use a slur. And they're not Native, keep in mind. They're not using a Native slur for themselves. I mean, because they're Native, they're just mocking Native people. So, I think it's encouraging to get a win. Cabazon, look, it was great that the Cabazons were able to stand up to the state of California and persevere in their desire to do gaming. But again, sometimes the devil's in the details. Now, I don't know. I haven't read the entire ruling, so I don't know if there's a couple of catch points in this the Wyoming versus Herrera versus Wyoming or Washington State Department of Licensing versus Cougar Den. I suspect that there may be, and or that the ruling and the legal dicta, the opinions expressed here, may not quite go far enough, and I'm sure that they don't, because oftentimes these things are limited to very, very specific language that is cited in the treaties. And again, rather than these courts saying if Native people didn't give up that right, then they maintain that right. The courts haven't gone that far. They have on occasion, but that's not the standard that holds in all of these cases. And obviously, even in these two cases, look, if Neil Gorsuch went with the other right-wing appointees, this would have gone the other way. And I guess to even put a little bit more of a point on that, I'll look when we come back after the break here at the bottom of the hour. I'm going to talk about a couple of other cases where it looked like there was a couple of bright spots. And then I'm going to look at talk about, again, Ruth Bader Ginsburg again, who is regarded, as the liberal darling of the Supreme Court, and yet she's made some terrible rulings. I mean, one in particular where she specifically cites the doctrine. I mean, she's a Jewish lady, and she cites the doctrine of Christian discovery as part of the justification for ruling against a native land use case. So I'll talk about that when we come back. Look, this is John Kane. This is Let's Talk Native. We'll be right back after this, and we'll do a little bit more.
Can't you hear the babies cry? Can't you see the parents try? Give a child a better life. He works an honest day for his honest pay. Still can't see him get ahead. Stay on that straight and never look back. Don't give up now. How long can it last? Yeah, the time will come. You know the time will come, baby, when nice guys don't finish last. When the good don't die, yeah, you know that time will come. Time will come. Say that your heart is cold, been hurt so many times before. Don't turn your back on precious love, 'cause there's somebody walking around feeling just like you are now. They ain't gonna come through your front door. Open up your heart and go get down. What goes around will surely come around. Yeah, the time will come when nice guys don't finish last. When the good don't die, oh no, no, you know the time will come, the time will come. Keep your dream alive. Keep it burning deep inside.
All right, thanks for coming back. This is John Kane. This is Let's Talk Native. Hey, I want to thank my sponsors. I want to thank Ross and Holly John and the RJE family of businesses, Eric White and ERW Enterprises, and a few others who are out there. In fact, I just got a text message this week, somebody who was a good friend of mine from the past, blast from the past, thinking about supporting what we do here. And so, again, that support allows us to grow out. Like I said, we're even test driving some other equipment here. Maybe something that will allow us to do a little bit more with this open broadcasting on Facebook and that kind of stuff. So always trying to do a little bit more, trying to improve the product daily, weekly as we go. Look, I also want to thank those of you who share the show, whether you share the show as a podcast or a video, or whether you do as my wife does, shares the Facebook live stream on a bunch of group pages, Native group pages. And feel free. I mean, look, if you're listening, Native or non-Native, and you think that this live stream should be shared, we are talking about some things that impact more than just Native people. But again, I've said it. I haven't said it in a while, but I've said it before. We're kind of the canary in the coal mine here. If we are being abused and being oppressed and having our rights trampled on by the courts, the police, by the state, federal government, or whatever else. It's just a matter of time before they start coming after other people as well. So that's why the fights that we have, and most of the fights aren't just for us. I mean, look, we battle over issues about bad legislation, environmental issues, any number of things, and that can impact us all. Hey, before I get back into the subject, I do want to again remind people behind me. I've got the missing and murdered Indigenous women's. Well, it's a banner, but it will be a flag, and of course, I'm rocking the shirt today. This is something that my friend James and I are working on to try to raise awareness, both with the image and with some of the networking that we plan to do. So we'll keep you posted as we start to do more in terms of trying to create a better alert system, and other support systems for victims and families and communities that are challenged by this terrible phenomenon that we call missing and murdered Indigenous women. And again, I need to remind people, even though we call it missing and murdered Indigenous women, it is it's men and boys, it's women and girls. It's not just women. It's just I think the women, the idea that we should be protecting our women, young and old, is such. I mean, look, that crosses all kinds of cultural boundaries. So it's something that we all need to do and we all should do. And this issue that we're facing has got so many issues related to it, including the desperate situations that many of our territories find themselves in, which contribute to the problem. So we get mired in this debate whether when somebody's missing, are they runaways or are they been taken? We have to battle, investigators when we do find a loved one that lost their life, whether they lost their life by suicide or whether they were murdered. And of course, as I mentioned in the last show, we've even seen a couple of heinous crimes where one where a Native woman in North Dakota had a baby cut out of her womb, and then now we just saw in Chicago last week that happened to another woman of color. Looked like, I think she was Latinx, and but again, an Indigenous person to have such a terrible thing, an Indigenous woman to have such a terrible thing happen to them. So this is what we're going to step up. So as we continue to show and try to raise awareness to the issue, we're going to try to get some flags printed up and some T-shirts, maybe some other merchandise printed up to raise money for the cause, to raise money for victims, and that's something that you can look forward as we go forward, I guess. All right, let me get back into it a little bit. As I mentioned in the first half, I'm sure Trump is not happy about one of his Supreme Court nominees siding with the liberals on Native issues, because Trump is not exactly a fan of Native people. I mean, he's called us down on many occasions, and mostly because he really sucked at doing managing casinos, and always felt like his problems with managing casinos was because Native people had an unfair advantage over him. And in spite of all of his resources and all of his so-called business acumen, this is a guy who couldn't make money even running a casino. And of course, we also know that he decides that he's going to mock Elizabeth Warren by calling her Pocahontas, and it just doesn't stop with this guy. He's clearly a racist, and it's got to be difficult for him to accept that one of in fact, his first Supreme Court nominee is actually ruling with the left on Native cases. But I do have to caution getting too excited or enthusiastic or maybe even enamored by Neil Gorsuch. Look, I'm grateful that he ruled properly, or seems to in this case. I know that there's, like as I said, even when we win, sometimes there's we get some of our rights trimmed at the edges, even in rulings that go our way. So I'm a little guarded on this thing, but it reminds me, Clarence Thomas. He was the only Supreme Court justice of color for many years on the court. He made an interesting ruling, or wrote an opinion in a case called U.S. v. Lara, and Lara was Billy Joe Lara, who, and I've talked about this case before, but I want to talk a little bit about what Clarence Thomas did in this case. What this case involved was it's a peculiar case because Billy Joe Lara was right on point with the whole missing and murdered Indigenous women thing and the violence against women. He was an abuser. He was beating up his domestic partner, and the police would show up, tribal police would show up, and try to I guess negotiate conflict resolution, I guess. But ultimately, Billy Joe Lara was a restraining order was issued, and he was from another territory, another reservation, not on the same reservation. I don't know if it was his wife or his girlfriend, but he wasn't from the reservation that his wife or partner lived at, and so the restraining order banned him from coming onto this reservation, and so that was he actually violated that and showed up back at her house, had another domestic disturbance, and when the police showed up, he punched one of the police officers, and then he was arrested, and I think he served like 90 days for assaulting a tribal police officer or something like that. But then the feds came back and said, whether it was that officer or another officer that was also assaulted by Billy Joe Lara, they said, wait, wasn't just a tribal police officer. This was from the Office of Tribal Justice. He was a BIA cop. He was a federal police officer. And so they charged him with assaulting a federal officer, which is a bigger offense than, of course, right? It's a bigger offense than just assaulting a tribal officer. So this case ends up being that whole double jeopardy, defense, right? So Billy Joe Lara says, "Well, you can't charge me. I've already been charged at the tribal level, and you can't charge me at the federal level because that violates the the double jeopardy rule." And the U.S. attorney said, "No, double jeopardy doesn't apply here because the tribal police officers and the tribal courts do not get their authority from the federal government." Really? That's what the U.S. attorney's arguing? And so it was a strange case because the U.S. attorney was arguing that tribal police got their authority from from the inherent sovereignty of the tribe, not from full faith and credit from the federal government. Billy Joe Lara was arguing, no, they only get their policing authority from the federal government. Well, it turns out Billy Joe Lara loses, and the court rules that the tribal courts get and the tribal police get their authority from the sovereignty of that territory, not from the federal government. And so Billy Joe Lara ends up getting charged with and convicted of assaulting a federal officer. I don't know how much time he got, but so even though Billy Joe, the native guy, loses, it was actually a win for native sovereignty in a way. But the interesting thing was, again, it was a close decision, but Clarence Thomas, he ruled with the liberals on this case, and he wrote a separate affirming opinion, and his opinion was interesting because he went on to say that past courts have been schizophrenic, and they seem to be all over the place on what sovereignty is. He says, I see no evidence that Congress, that it was the founding fathers intended Congress to have the power to regulate the metes and bounds of tribal sovereignty. He says that's what's considered the plenary powers doctrine of Congress. He says, but I see no evidence of that. There's nothing in the Constitution, and I agree with him on this. We're mentioned 3 times in the U.S. Constitution. One which has to do with apportionment of taxes and congressional representation, where we're referred to as Indians not taxed, and they're saying Indians not taxed will not be afforded apportionment for congressional representation or apportionment of taxes. So that's in one clause of the Constitution. The other 2 places that were mentioned is in the treaty clause. We were included with an executive authority where the president has the right to negotiate treaties with foreign nations and Indian tribes. And then, of course, pending, it would go to the advice and consent of the Senate. But the president had the authority to negotiate and to negotiate those treaties with tribes, with Native people, and with foreign governments. So we're mentioned in that part of the Constitution. The other place where mentioned is in the Commerce Clause. And this is the one they put a lot of weight on. And in the Commerce Clause, it says, Congress shall have the power to regulate commerce in and among several states with foreign nations and with Indian tribes. Now, it should be obvious when I say it doesn't say Congress has the power to regulate commerce of Indian tribes. It says that it has the power to regulate commerce with. So it means it can regulate their people as they conduct commerce with us. With us. So it doesn't say that Congress has the power to regulate us. It has the power to regulate their people interacting with us. And yet, that's where this whole notion that that the founding fathers intended Congress to have power over Indians. Well, simply not true. And Clarence Thomas recognized that. At least in this case, in this case involving Billy Joe Lara. And he invited, in fact, in his ruling, and I encourage you to look it up. I mean, not everybody likes to read this stuff. I mean, but if you look up U.S. versus Lara, and it's Lara, U.S. v. Lara, and read Clarence Thomas's opinion. It's not a long one, so I mean, when you read it, it sounds really promising. It sounds like Clarence Thomas, even though he was nominated by Bush to sit on the Supreme Court, I think it was Bush. Yeah, it would have been Bush. Again, Republican nominee. He seems to have an open mind about native sovereignty. Now, but when you read it though, it sounds promising. But then I understand that what Thomas is really asking for is for some of this stuff to become settled law. He talks about some of the fixes that they try to do because of the inconsistencies of the court and how they fail. But I don't think he wants to recognize our right to a free and independent existence. But he's saying the current law and the current ruling and the current legislation doesn't properly, and the Constitution doesn't afford them the kind of power that has been. Again, he took the case, took the position that he can't find in the Constitution or in any law where Congress has been granted the authority to regulate the metes and bounds of native sovereignty. But you know what? Even though he said that, and this case is 30 years old, at least, Clarence Thomas hasn't been a champion of Native people. So I bring this up because I don't want people to think, okay, well, Neil Gorsuch is our guy now. Because Clarence Thomas wasn't our guy either, even though he ruled the right way in U.S. v. Lara. And of course, I got to get into Ruth Bader Ginsburg. Now, Ruth Bader Ginsburg is considered, one of the most left-leaning, one of the most liberal justices. I mean, look, they did documentaries on her. There was I think they did a multi-part series on television. One of the networks did on RBG, and people chant her name. I mean, they rave about, her rulings. But I'll tell you, she hasn't ruled well when it comes to Native cases. Look, she's on the 5 part of the 5-4 decisions, that Gorsuch ruled on. So I'm not saying all of her rulings are bad, but I can't get away from the ruling that she made in the Oneida case. And we're going to shoot a video probably this week where I'll get into this a little bit more specifically. But one of the things that I think really has to, again, be remembered is the Oneidas had a case where the city of Sherrill, which is the municipality where the Oneidas had bought some land to take it back. Now, they didn't sue and sue white people off their land or anything like that. They bought land and then they put a couple of enterprises on it. They got their convenience stores they put on there, and the city of Sherrill was trying to tax them. They wanted to tax the Oneidas. Now, the reason the Oneidas did this is because they have a Supreme Court ruling that is now decades old, where the Supreme Court ruled. And it wasn't just a 5-4 decision. I think it was, 6-3. I don't know. It wasn't a unanimous decision. But they have a Supreme Court ruling that acknowledges that there's an area of central New York that the Oneidas have a right to sue for title and to claim title of the land. Now, it's not a clear ruling that gives them the land, but it says they have a legal claim to the land. So the United States said, well, we've got that. We're gonna purchase some of the land back, and we're just going to assert that it's that we've reclaimed it. We have, the courts have ruled that we have a right to claim title. So now we're not going to take the land back. We're gonna purchase it. So they purchase it in the open market and put some enterprise. Now keep in mind their entire casino is on purchased property as well. So although this wasn't the land in question with the city of Sherrill, so the Oneidas actually had success in the courts, but it kept getting appealed. It appealed all the way up to the Supreme Court, and now they had won in the lower courts, but at the Supreme Court level, Ruth Bader Ginsburg, and I don't remember how skewed the what the numbers were. It was 5-4 or 6-3. I don't know what. I don't remember how it broke down, but she wrote the opinion on this thing when they ruled against the Oneidas. The first thing that she had to do, she had to overturn. I mean, keep in mind, they had to overturn the lower court's ruling. And one of the things that the lower court had done was eliminated a few legal principles. One was called the doctrine of impossibility. Yeah, there is such a thing. So this uses a case out west where, and I want to say that was Yankton Sioux or something like that, where a court had ruled that it was impossible for a native entity, a tribe, native peoples, to reassert lands or sovereignty on lands that they had lost, even if it was lost by fraud. They said once the state or the federal government had asserted jurisdiction and the municipal sovereignty or whatever, once it became under control of a non-native government, the native peoples could no longer assert governmental control over lands. They called it, and they created this thing called the doctrine of impossibility. Now, the reason that this came about was really based on this notion that suing white people off of land and then reclaiming it was the problem. So that's what the whole doctrine of impossibility was not, not exclusively, but a big part of the doctrine of impossibility is geared towards this idea of removing white people from land and removing government, non-native governmental control over land. And so that's what this doctrine of impossibility. Now, the lower courts have said, well, doctrine of impossibility doesn't apply here because the Oneidas didn't remove anybody. They just purchased it on the open market. But Ruth Bader Ginsburg said, no, the doctrine of impossibility does apply here because it is very disruptive to white people to have lands taken out of their jurisdictional control. I mean, it's one thing to say it's very disruptive to white people to have them forcibly removed off of lands. That's, look, I think that is disruptive. I'm not saying it's wrong, but I understand that it's disruptive. But to suggest that it was disruptive, look, the only thing it disrupts is tax base. And the reality is the city of Sherrill has been collecting, taxes on land that was illegally gotten. And of course, so that's what Ruth Bader Ginsburg had ruled. And the crazy part is she ruled this based on a case that was maybe, I don't know how many years old, but it was it was a dated case, put it that way, and it was based on a tribe out west. When a tribe much far closer, but still out west, when the Senecas had a case. Now this was ruled in 2005, and in 1990, the Senecas had a specific piece of legislation that passed through Congress, Senate, and the House to fix the Salamanca lease settlement, the Salamanca lease, and this was called the Salamanca Lease Settlement Act. And this act of Congress paved the way for the Senecas to reacquire lands that was previously theirs. That was their ancestral lands. They were given a sum of money to compensate for the bad lease that the city of Salamanca represented, and then they were told, with that money, there's only a one paragraph section called the Land Acquisitions Clause on this piece of legislation that allowed the Senecas to reclaim land anywhere within their ancestral homelands, and not just reclaim it as trust land, but take it back as original title. So Ruth Bader Ginsburg saying that the Oneidas reacquiring lost land should be limited by the doctrine of impossibility, citing a case out west, when 190 miles down the road, the Seneca's got to have a specific piece of land, not just a ruling by court, but a piece of legislation passed by the entire Congress of the United States that says, no, it's not impossible for you to take land back that was and take it back under your jurisdictional control. There is no doctrine of impossibility when it comes to and again, this is specifically Haudenosaunee, Six Nations. I mean, it's us, right? Now, why do I say that? Well, because part of the rationale for Ruth Bader Ginsburg citing this doctrine of impossibility and applying it towards the Oneidas shows up in her footnotes. Because in footnote number 1 of this ruling that she wrote, she cited the doctrine of discovery, the doctrine of Christian discovery. She said, under the doctrine of discovery, lands held by Indians became vested, or occupied by Indians became vested in the sovereigns. First, the discovering nations of Europe, then the states and the United States. So for one thing, no, they didn't. No, they didn't. I mean, I understand that's what the doctrine of discovery says, but when it comes to the Six Nations, we had our lands very specifically acknowledged as ours. So she cites as footnote number 1, the doctrine, and this is a Jewish lady, citing 15th century church dogma as part of her rationale to even use this other doctrine of impossibility. So she's saying her mind is skewed by 15th century church dogma. At the foundation, she is saying Native people lost the right to claim title to land once white people came. That's basically what she's saying. And then she cites these other cases as part of the rationale. The idea that this Jewish lady on the court, again, liberal Jewish lady on the court, would cite the doctrine of discovery as footnote number 1 against one of the Six Nations, when we have language in treaties too. We have language that where the United States, George Washington, specifically acknowledged that our land was ours. I mean, he didn't say, well, the land, ceased to be yours because, white Christians came here. But that's what Ruth Bader Ginsburg said. She said, our lands, the lands occupied by Native people, she didn't say how it got vested, but she says it got vested in the sovereigns. In other words, we weren't sovereign. So, I mean, and look, this is what she cited as her explanation or her definition of what the doctrine of discovery is. She says Native lands simply got vested in other people, the Christian nations of Europe. She didn't say how. She didn't say what the process is. Oh no, the process is simple. White people saw your land and then claimed it. She didn't say why or how it would become vested. What's the legal rationale? She didn't even try to. I mean, she could have at least cited Johnson v. McIntosh. No, she went right to the 15th century dogma. Now, here's what I find absurd about that: the idea that a woman of Jewish descent, and look, we all know what is involved with Israel and and Jewish land issues and that kind of stuff. We all know that. You would think that this woman would have been sensitive. And maybe she is sensitive. Maybe the whole idea that she looks at us like Palestinians, and maybe that's the rationale for her to suggest that a whiter breed of people can assert claim to lands. Not Christian. I mean, she's not Christian, and the church and the doctrine of discovery is a Christian thing. But there is a connection between those two. I mean, who knows? I mean, the Judeo-Christian belief, I guess. But this lady could cite 15th century church dogma and cite a case, out west in this doctrine of impossibility, BS, ignoring the fact that the Senecas had the Salamanca Lease Settlement Act in 1990, and also ignoring that, of course, this is in 2005 that she's making this case, but you can't find a justice now. In fact, you can't even find a lawyer who's willing to say, okay, we should cite the specific articles of the UN Declaration on the Rights of Indigenous Peoples in our case. I mean, most lawyers defending Native people say, no, don't do that. You're just wasting your time. Well, wait a second. If Ruth Bader Ginsburg can cite 15th century church dogma in the footnotes, and again, the footnotes are the foundation, essentially, of her ruling, right? That's what footnotes are. So she could cite 15th century church dogma as the foundation for her ruling. Well, then why can't somebody cite a UN declaration, signed by the General Assembly, approved by the General Assembly in 2007? I dare one of these justices to do something. And you know what? I dare a defense attorney. Look, it doesn't hurt to have extra material in a case. And and frankly, if we challenge, like the Yakima did, the Doctrine of Discovery, if we challenge Johnson v. McIntosh, if we challenge some of the violations that the United States, makes every single day of the UN Declaration on the Rights of Indigenous People, then let a judge say, well, we're not bound by that. I mean, look, there's a part of me that when Ruth Bader Ginsburg cites the Doctrine of Discovery, I'm thinking, there, good. I'm glad she did it. At least she's admitting how weak their case is when it comes to Native issues, that they have to cite something as racist as the Doctrine of Discovery. They have to cite that racist dogma, 15th century church dogma. I mean, something that nobody would accept as valid rule of law today. But because it's been enshrined through case after case after case, hell, she didn't even bother citing the cases. She went right to the church dogma. I mean, how absurd is that? But she did it. And to me, that's weakness. Now, the sad part is that the Oneidas, defended themselves poorly. And of course, then they turned around and made a deal on, giving gaming revenue away to secure their land holdings in such a way. But they made a terrible land deal afterwards. And, this is where some of our own strategy on land and on, our legal matters sometimes just hurts us. And the Oneidas could have won that case. They should have won that case. And the fact that rather than being preemptive on things like, like the Doctrine of Discovery, like the Salamanca Lease Settlement Act, their lawyers just dropped the ball. And so the Oneidas got screwed. But having that ruling there, having, again, one of the liberal justices cite this church dogma, there's some value in that because we can challenge that. And again, my hat goes off to the Yakima for challenging the state of Washington and going all the way back. Look, if Ruth Bader Ginsburg can cite the Doctrine of Discovery in a land claim case, then we should challenge the Doctrine of Discovery in every land claim case, because we should never accept the premise that that Justice John Marshall put in Johnson v. McIntosh or Ruth Bader Ginsburg put in City of Sherrill versus Oneida, that somehow our lands simply became not ours anymore because white people came here. And that, as absurd as that sounds, that's the belief. That's what Ruth Bader Ginsburg, again, liberal darling on the Supreme Court. So I bring up Clarence Thomas and I bring up Ruth Bader Ginsburg because I think it's real easy for everybody to get excited about these two rulings by at the Supreme Court. And again, Neil Gorsuch is is just one of 5 justices who ruled this way. Of course, what seems a little extraordinary is the fact that he is a Trump appointee. He is considered the right-leaning side of the bench, and of course, he is the only guy from out west. And I find it hard to believe that that somebody just from being out west makes him sympathetic to Native issues, but at least he's applying basic U.S. rule of law, which isn't always right. I mean, and again, it has a lot of it. It never goes far enough, but at least he went as far as he did. And again, I applaud the rulings, but I will say I applaud the defense. When I see a case handled poorly, like the Oneida case, I mean, it just makes me scratch my head. And I've seen that. Look, I've seen the Senecas handle the fight against the state over taxation. And where a judge literally challenged them, are you going to use, or do you want to cite your treaties? I mean, it's almost like, and the fear, it's almost like the judge was challenging the Senecas. And the fear was, oh, we can't let a white man in a black robe rule on our treaties. They weren't our treaties. It's theirs. It's not ours. Look, there's no such thing as federal Indian law. There's federal law about Native people. There's federal law about Indians. And most of it is bull. Most of it's terrible. And you know what? Let Judge Arcaro rule badly against the Canandaigua Treaty. I mean, let's stack up the language of Canandaigua, even though I'm not a big fan of the treaty. But let's stack up the language where George Washington essentially signs off on this notion that they're acknowledging that our land is ours. And the United States will never claim the same, nor will they disturb us in our free use and enjoyment of that land. Let's stack that up against the doctrine of discovery. So Ruth Bader Ginsburg or anybody else will never cite that crap again. And then let's start pecking away. Let's start lifting off a card off of the house of cards their laws have been built upon. Or, you know what? Let's knock the whole damn house over. But we've got to do something. We can't let lawyers tell us, oh, no, don't cite the UN Declaration. No, look, I know that this thing has no bite, but it has even less bite if we never even cite them. Let's not challenge the doctrine of discovery. Let's not challenge Christian ideals. That's not a Christian ideal. It might have been a church dogma, but I think you'd be hard-pressed to find some devoted Christian who will tell you, oh, yes, it was God's will that we took your land. Although I will say, what were those guys, Jake, that were in Washington with the whole Nathan Phillips thing? What do they call themselves? The Hebrew, the Black Hebrew Israelites. They claimed that we lost our land because we were heathens, and that's the reason we lost our land. It was God's will that white people took our land. So maybe there are some people, and those are black guys, but. I mean, we got a Jewish woman citing the doctrine of Christian discovery. We got the Black Hebrew Israelites saying that that it was God's will that to take land away from us. Us. What do they call idol worshipers? I guess is what they call it, because we worship totem poles and eagles or something like that. So anyway, I did want to get through. I think it's really easy to get excited about these rulings, and we should know what they really involve. And I'm glad for the rulings, but I'm not gonna, join the Neil Gorsuch fan club just yet. So, all right, we'll be back on Saturday. We may get a video out this week as well. So we'll see what we can do there. But otherwise, we'll be back here on Saturday, and see you then. This is John Kane. This is Let's Talk Native. Yahweh.